Hello, everybody. Welcome to the next installment of our clown show we call the Justice Revolution. I'm your host, James the Patriot. I have my beautiful co-hosts with me, Erica from the beautiful state of Indiana. Say hello, Erica.
Hey there.
And we got Justice, my co-host and producer from up north. Well, actually, I'm north of you. You're south.
Yeah.
I said that last time, but I say north because you live up in the mountains.
Well, we're both upstate if you want to.
Yes.
Yep.
Still
Hi,
trying
everyone.
to unbury herself from about 15 feet of snow.
We'll get after snowy day.
Yes. Welcome, everybody that's joining us live stream. We appreciate you guys being here. Got a lot of fun stuff to talk about today. I've got some really fun stuff to share. But before we get into that, let's get a quick update on where everybody is. Erica, what's new with you? What's new in your life?
Oh, my goodness. Major week upcoming here. I don't want to jinx it yet by saying too much, but I think that by the next video that we do, I might have some pretty big updates.
Ooh, this is gonna be good.
And
if that's not a cliffhanger, I don't know what is.
Justice, you know some of the stuff that I'm working on. I've got a lot of things cooking, and so yeah, I'm pretty excited.
Awesome. That's good to hear. Justice, so what's new with you?
Not a heck of a lot. Still going down the motions of learning and dealing with snow and egg shortages. And
oh my goodness,
it turns out it's the feed, folks. If you want an update,
yeah, it really is.
Numerous friends have switched their animals to horse feed and goat feed and homemade feed, and within 3 days, their chickens were laying eggs. So,
really,
yep. Crash being one of them.
Well, how is Crash? I haven't heard from her forever.
She's good. We're doing a broadcast on Thursday with Dr. Neil, the melatonin expert.
Oh, good.
Yeah.
I want to see
good.
that.
For those of you guys who don't know what I'm talking about, I met James. I was doing a broadcast. It's called Crashing Justice with a friend. I'm going to plug this for a minute, not to plug it, but just to explain.
Go ahead.
And I met James in Utah, going home to home, teaching people about taking back their rights. And we connected, and it blossomed into Let's Make Your Voice Bigger, which led us here today. But Crash and I took a little bit of a break. We did podcasts for almost 2 years, and YouTube hassled us because everything you need to know, they want to take down.
Yeah.
And so we took a break, but we are going to do our first broadcast in a little bit. That's been for a little while on Thursday with Dr. Richard Neal. You guys can Google him. He's an amazing individual, very well accomplished, and one of his expertise is melatonin. He saved countless people from which we can't say, with it. So that'll be Thursday on Crashing Justice. So I'm excited to do that because it's been a while for she and I to do a broadcast. So
that's awesome.
Yeah. So that's what's new, actually.
That's great.
Yeah.
Well, thanks you guys for giving us a brief update on your lives and things are going on with you guys. So
thanks. Well, what about you?
I'm really excited for our next broadcast because I'm really hoping Erica has some good stuff to share with us.
Yeah. Well, tell us about what's new with you real quick in your
just the same old. So just some updates on some of the cases we're working. I know I've filled a lot of people in on the situation with your case, Justice. So full disclosure, I had never challenged a mortgage foreclosure before, so it was kind of uncharted waters for me, but I found a complaint that I thought was going to work, and unfortunately it was very poorly written. I didn't write it. I just borrowed it and rewrote it for Justice's example. Well, long story short, it was poorly written, and we didn't get a favorable decision in federal court. So now we're going to do Randy Kelton's method, where he says, I'm going to take him to the Fed or to the state, and win, lose, or draw, I'm going to sue him in the other court. So
is there something important? Because we do have one of the things, Erica and Kathleen and I had a good 2-hour talk the other day, and a big portion of it was the influx of the mortgage situation. So is there anything important in that, James, that you feel like that would be helpful to share folks what to do, what not to do in a nutshell?
Yeah, I want to do, once I get the new complaint rewritten, I want to do another episode on that complaint, if you're okay with that.
Yeah, I'm fine. Yeah, yeah.
So so if people are having issues with their mortgage company, and more so not mortgage company, but mortgage servicer, because that's usually where the problems come in. Is whoever is sending you statements demanding money from you, 9 times out of 10, they're not typically the owners of that actual note,
Yeah.
the promissory note. They're just servicing. They're contracted by the owners to collect money for them on their behalf. The struggle is that when when you have a scenario where you're unable to pay and the servicer is unwilling to work with you and they want to foreclose, they always list the foreclosure, the entity on the foreclosure as the servicer. And that's not how it works. You can't foreclose unless you own the promissory note and the mortgage deed. Those two have to be together, those two documents.
That's really important to know.
Yes, they must be together. And 99.997% of the time, if you go and you close on a house and you sign your documents, those two documents are separated. And one is sent off to a pooling of other promissory notes, and they're put together for investors to purchase and so on and so forth. So we kind of got off on a tangent here, but it's important information to know. So for those of you who unfortunately, like Justice and I, live in a state that allows a non-judicial foreclosure process, just because there's a non-judicial foreclosure process does not mean that they do not have to verify and validate the documentation you're asking for. In Justice's case, they've refused, and they just continue to move forward. Mm-hmm. So this is what's frustrating, is that we have to initiate the legal action, which we will do. We've already beat them up somewhat in the federal court. I've gotten them to take some positions, which is good, because there is this doctrine known as equitable estoppel. And once they decide to take a position, I can take that information and incorporate it into my new complaint and sue them in state court and say, hey, the court records over here say that they stated this. So we have it on the record here. So we're going to be using that to our advantage.
Great. Okay, can't wait to do a mortgage series. Yeah, yes. Flat out refused, just like ignored, disregarded.
Yeah, it's going to be good. It's going to be really big, and we'll talk a little bit more about that. But okay. Let's get to the topic at hand. Okay. We've been talking about the last, how many episodes? 3-4 episodes now? I don't know. We've been talking about jurisdiction. What is it? What it is? How the court gets it? What can the court do if it has it? What can the court not do if it, or what do they often do if they don't have it? So, real quick, let's give a brief refresher. Erica, you want to give us that refresher? I know it's fresh on your mind.
For jurisdiction?
Yes. So there's
you have to have subject matter jurisdiction.
Okay, that's first.
Okay. You have to have that, and that includes a standing. Your in personam.
Yep.
Jurisdiction.
Mm-hmm.
And then place, right? The
property.
Property.
Is that what you're thinking of?
No.
Venue. Maybe you're thinking of the venue.
There are 4 legs.
Yes. So it just matter? Yeah, as a quick refresher. So if jurisdiction is a table that has 4 legs, each one of those 4 legs must be there. Otherwise, the court is deprived of any kind of jurisdiction. So the first 2 legs are a plaintiff and a defendant. Those are the first 2.
Yeah.
Right?
Right.
So you have those 2 taken care of. Then the second is in personam jurisdiction, or personal jurisdiction, which is the court gains by when if you're the plaintiff and you're suing someone, you properly serve them a copy of your complaint. There is a summons from the court that's signed by a court clerk with the court seal stamped on there. So the individual receiving that goes, okay, this is legit. This is real deal. You also must file an affidavit of service into the court record. That's required to be there. That takes care of personal jurisdiction. The last and the often overlooked is the subject matter jurisdiction. And there's actually 2 parts to this, right? So there has to be the cause of action or the statute or the common law authority that you're moving under. So, for example, if it's the common law cause of action of trespass on my property or conspiracy, or abusive process. Those are all common law causes of action. That's the first part of it. The second part is there must be someone with standing that has sworn to the veracity of that complaint. They have verified that complaint. And they've done that through either an affidavit or they put a jurat within their complaint itself, which now makes the entire complaint an affidavit. Now the court has facts before it that it can adjudicate. When all four of those things are there, the court has subject matter and the court has personal jurisdiction to adjudicate the case. Now, in cases involving property like mortgages, there is one other leg of that table that must be there, and that's called in rem jurisdiction. The moving party must prove that they have an interest in the property. So like in Justice's case with the mortgages, the mortgage servicing company or whoever is trying to effect the foreclosure, they have to prove to the court that they have jurisdictional standing called in rem jurisdiction, which would allow which would give the court the necessary jurisdiction it needs to adjudicate that matter. So, have I confused the heck out of everybody?
No, I was following right with you.
Okay.
I'll remember in rem next one. By next one.
Yep. And in rem only occurs very frequently, but situations where you're going to come into that is going to be any type of government agency or a company that's moving against your personal property. So like your home, it could be your money. So taxes, if it's a corporate, if it's a county government or something like that that's trying to affect a tax sale on your property, they've got to prove they have property. They have to prove they have in rem jurisdiction.
Right. And the interesting thing was in my case, I don't want to get off on mortgages,
You're
but
fine.
they only, because I started asking them for proof, that's why they got the servicing company went ahead and tried to get an attorney to come after me and foreclose. And that's the only reason, because we said, you know what, we want to check out our mortgage standing. It jumped hand after hand after hand. And we just said, who owns it and who has the proof of all this? Because we don't know who we're dealing with anymore, really. And then that's when they decided they wanted to play that game. So we went after them instead because they didn't want to provide the information.
And and just so everybody know, you have every right to demand that information.
Right.
If they are threatening to deprive you of your property, you have the right. That's part of your due process rights to verify, hey, prove that you have the standing to do this. Prove to me that you are the one who is actually harmed by me not, I'm not saying that you haven't paid your mortgage and stuff. I mean, in your case, Justice, it makes your head spin. I mean, all of these things that you guys went through.
Right.
It's terrible. And don't get me wrong, people. I'm not advocating that you don't pay your bills.
Right. Right.
Okay.
There's a lot to my story.
Yes. And maybe one day we'll share that when we've got about 5 hours to do so. Because it's really, it really does make your head spin. But what I'm saying is if you accept the obligation, pay your obligation, but there's no reason why you can't make sure the other side is doing what they're supposed to do. There's no reason why you can't verify that. And
for them to claim so when you ask for this, they send you back a stack of photocopied information. Yeah. And for them to claim that is valid proof, it is not, because in which case we would be able to go to motor vehicle or walk up to the airplane with our passport, a photocopy of it, and be admitted on as a valid identification. So photocopy is not a valid contract, a valid agreement, or valid document.
Not only that, when part of the validation and verification process requires that whoever's report or giving you that information, they're required to swear under penalty of perjury that it's true.
Right.
And they never do. Right. They never do. Because they're not going to stick their neck out there. I just work here. I'm not sticking my neck out here. I'm not going to go to jail. So, all right. Anyway. So that's good. That's our refresher of jurisdiction. Glad to hear it. So I am going to share with you guys. I had someone reach out to me, and I'm, for an interest of privacy. I'm not going to share with you this individual's name, but they live here within Utah, and she called me and told me about the situation that she had, and so I said, okay, well, why don't you do this? Why don't you send over to me a verified copy or a certified copy of the court records so far. So send over to me everything that you have. She actually has 2 separate cases. This is the first one I want to show you. This is the precipitating case. And we'll talk about the ridiculousness of the second case here in a second. But long story short, she was accused of domestic violence assault of her boyfriend, partner, whatever. And the prosecuting attorney, who is he either works for or is contracted by the city of St. George, filed these charges. So this is what you're going to see 99.997% of the time in these courts. Now, this is the first thing I want you guys to notice is this is in the Washington County Justice Court, right? Justice, do you remember
that in St. George, Washington County?
Yeah, this is here in Utah. Yep.
Okay.
Washington County. Do you remember what I told you about the justice courts here in Utah, what they are?
Administrative courts.
They are. Exactly. They are, under Utah law, the justice court is a court not of record. They're not required to keep records. They don't. And the reason why the Utah Constitution and why the legislature set them up was to handle administrative matters of our public servants. So if one of our public servants does something they're not supposed to do, this is the court where they're supposed to go. But what's happened is they have decided to take every single man, woman, and child, practically, that lives here within this state and prosecute them for all of these ridiculous misdemeanors here in this court. Because, again, and I don't want to make people get too far off into the weeds here, but if you read the laws, the statutes, and let me just back up, by the way, okay? It can get really confusing when we refer to the statutes that are passed by the legislature as laws. They are technically laws. However, they're not laws that govern the actions of you and I, unless it's in accordance with the enumerated powers of the Utah Constitution. And the same as any state you live in, or even in another country. So, Ian, I know you're up in Canada. Canada has a constitution, albeit that it's not very good from what I have seen. So as long as they are moving within the enumerated powers, then the law is binding upon everyone. But anytime it infringes on anyone's rights, which 90% of these misdemeanors do, then it is null and void, but they still move you according to the procedural court. So that's where this is. So what happened back in October of last year? Police are called to a situation, and this is the affidavit of probable cause from the arresting officer. So the first thing that I'm going to do, if I'm going to attack the jurisdiction of one of these courts, I'm going to pick this thing apart. And we're going to read this because I want to get your opinion, Erica and Justice, on what you see here. Obviously, I blacked out the names for privacy purposes.
So in a nutshell, the person you're helping is a female, and the male has complaint that she physically abused him?
Sort of.
Okay. Okay.
Sort
I just want to get the parties correctly. Okay.
Yes. So, yes, there's a male and there's a female who allegedly got in some type of an altercation. And from my understanding, they were charging them both.
Okay.
Okay. So this is the female. She reached out to me through a friend of mine, through a friend of mine who lives in southern Utah. And she said, "Can she talk to you?" So I spoke with her, and Justice knows I'm a pushover. I really can't stand. I can't stand to see injustice like this, and so I wanted to take this one on. So after reading this affidavit of probable cause, and then the information that was filed, I formulated a plan. But let's read this first. So,
thanks, bud. This
says that on October 21st, at right about 9 a.m., it says officers responded to the area of a donut shop for what was called a family fight. So it says the reporting person, so whoever it was that called 911, stated a male and female were physically fighting inside a vehicle. While officers were responding, the female was observed leaving the scene in a white SUV. Officers made contact with the male, who initially stated he was in a verbal argument with his girlfriend and that they are in a sexual relationship. He stated she was upset over money issues and left the area after kicking the door of his vehicle. While speaking to him, she drove past the scene and contact was made with her. It was discovered that she was upset with him because she was pulled over by the police and he did not stop. They were in separate vehicles. She found him parked at the Czech City and confronted him about not stopping. He spit at her, and this upset her even more. She tried to spit on him, but was unable to. Oh, crap, I forgot one. Sorry. Ignore that name. She went to her car, grabbed a glass bottle, and tried to dump the liquid contents onto him. She threw the bottle at him. It hit his windshield, and she kicked, she kicked the door. She again approached him and started to hit him, and then got in her car and left the area. Contact was made with the witness, who stated he became alarmed at what he saw and called the police. The witness stated she appeared to be the primary aggressor during the incident as she approached the vehicle, while I believe that's him told her he did not want to talk to her and told her to go away. The witness stated the female hit the windshield with the bottle. It was a glass bottle, and this should say kicked, but it says licked. So apparently there's whatever was in the bottle was worth licking the door over.
She might have licked it. Who knows?
That's what I'm saying. Hit the windshield with the bottle and licked the door. The witness stated he was unsure if the female tried to hit the male with the bottle or if she threw it at him, but it ended up on the ground. Video surveillance was obtained from this Czech City where it shows she was hitting the vehicle and appears to hit the male. She was arrested for this devious domestic violence, assault, and disorderly conduct. I placed my handcuffs on her, checked them for proper fit adjustment, and double locked them, was then transported to Washington County Correctional Facility without incident. Okay. Before I go on, I want to get your thoughts on what you guys just read there. Anything jump out at you guys?
It doesn't say that he was bringing complaint against her. It's just talking about the one injured. The one injured.
The victim?
Right?
Yeah.
The victim. It's all about the witness's report and the police officer coming on site and the police officer bringing charges against her for domestic violence, assault, but there was no one was standing, was coming up and being like, I've been injured.
I'm glad you caught that, because I caught that too. Anything you caught, Justice?
Well, I was thinking the same thing. I thought, me knowing the size of the town, do they know him? Because he got away, she didn't get away. The cops went after her. Meanwhile, he was parked, but the cops weren't. Talking to him, which was interesting.
Yeah.
Is there some sort of particular interesting bit that they mentioned that they were in a sexual relationship?
Yeah, there's a reason why that's there.
There's some legal reason that it's connected there?
Yes, you'll see why, but it still fails to meet the burden, but you'll see why. Okay?
So it's a domestic dispute.
There you go.
Theoretically, or...
Mm-hmm. Yeah, you'll see exactly why that's there. But let me go back to that again.
Was there alcohol involved?
No alcohol was involved. Nope. Okay. So yeah, you guys are spot on. This is the affidavit of probable cause from the arresting officer. Now, the first thing that stuck out to me was, after reading this, I'm going, this is all based off of hearsay evidence.
Hearsay, right?
This isn't based off of the officer's personal knowledge.
Is there any statements by either one of them in this? Or this is just the officers?
Nope. So she gave over to me everything the court has. This is the only affidavit that is on file.
Wow.
This is it.
So the police officer didn't take statements?
No, if he did, I don't know. It's not here. So whoever this witness was, it says this witness that called the police, I have no clue who it is. Okay. That right there is a major red flag.
Yeah.
Because don't I have a right to face my accuser?
Mm-hmm.
So if this witness is the one that was claiming to be, because again, according to the 911 call, this witness would essentially be the victim. But in this case, since it's a domestic violence, well, that would mean that the cohabitant or whoever it is that lives with this individual that's being charged would be the victim. But I don't see any affidavit from the victim stating injury.
Right.
So, this is very concerning. Oh, frick. I forgot to do another name there. Sorry, guys. Ignore that name. And I apologize.
You did your best. It's okay.
Yeah, well, I mean, this is public information, but still, I did the best I could. So, and she knows. I told her I was gonna do this. So,
well, someone just posted in the chat. Heather McEwen.
Yes, that's who it is.
Is in the chat. Okay, so she's willing to interact here.
Hey, Heather.
Yeah. Sorry, Heather. I just
would Heather like to come on live with us? It's up to you, James, because I can get her a link.
If she wants to, she's more than welcome to. I'm not sure though if she's able to. I can't remember what her schedule was today. So
okay, Heather, if you would like to come live, email the Justice Rev to 2022 at Gmail. That's James' email. The Justice Rev 2022 at Gmail, and then I'll send you back a link. So I'll just check it if you want to. You don't have to say yes or no. I'll just look at the email. And then we'll have you on and you can have your voice heard.
Yeah. So maybe she can add some like, oh, she says she can just comment in the chat. Okay. Thanks, Heather. And again, I try to do the best I could to block out everything. I apologize.
Okay.
So, all right. So that's the affidavit of probable cause. So now this document alone is not enough to charge someone. So they have to file what's called either you have to take this information to a grand jury to get an indictment, or in this case where it's a misdemeanor, they can just file what's called an information. But guess what? The information has to have certain stuff. So let's go to that. Okay, here is the information. This is what started the case, right? So, the plaintiff is City of St. George.
Uh-oh.
Yep. Big uh-oh.
Yeah.
Okay. That should tell you right now, anytime you guys get any type of criminal case or anything where it's being prosecuted by the city of, or the county of, or the state of, you are being prosecuted in an administrative court. Mm-hmm. The way this is supposed to work, if this was a true Article 3 court, this would say the people of Utah. Plaintiffs or plaintiff versus so-and-so. Okay? That's how this is supposed to work. But in this case, City of St. George. Okay, so City of St. George is alleging that they have standing to bring this case. We'll get to that in a minute. Okay? This is what it says. The City of St. George, through the undersigned prosecutor, alleges that there's no, I guess the gloves are off now, that Heather committed the following criminal offenses in St. George, Utah. Okay, here's the first one. Assault, domestic violence, a Class B misdemeanor. I'm not going to read through all of this stuff because it's boring and I don't want to bore people to death. It says basically that she attempted to hurt someone, and look at this bottom line here. I don't know if you can see this, Erica. Can you read that?
Yeah.
Can you read that for us? You see what that says?
Furthermore, the defendant was a cohabitant of the victim.
There you go. So you asked the question of why does it say the sexual relationship? That's it right there. But it still is very vague. Just because you're in a quote unquote sexual relationship with someone doesn't necessarily mean you're living with them. Yeah. The second one was disorderly conduct. You'll see how now real quick too, disorderly conduct. Did you guys, going back up here, when we read this affidavit of probable cause, does that sound like disorderly conduct to you?
No. Even
if it did, who saw this and who's bringing that claim?
Yeah, how does an affidavit like this that the police swore as a witness turn out to be the plaintiff of the county or the city or whatever?
Yeah, they can't.
He's swearing to the hearsay of someone else.
Mm-hmm. Exactly. he's just made a mockery of himself because he did not personally witness this. Okay?
So keep going. I've got questions that I know I'm going to jump the gun that you're going to get to.
No, you're good. You're good. So
Heather, I just want to say I'm really sorry that you went through it, regardless of the domestic disputes. Men are just 10 times stronger than women, and it's just shouldn't happen. It's just so. I hope you're doing okay.
Yeah, she seems to be doing in a better place. I mean, obviously, it's still a very delicate situation because they're. I don't want to jump the gun here, but this is the precipitating case, and the reason why it's a precipitating case is because when they released her from jail here, they allegedly told her she's not allowed to go have any contact with the victim, which would have been this other guy. Well, he had her car, and she felt like it was an ambush because when she went to get the car, there was another St. George police officer there and arrested her for that one. So that's a whole other issue, which I will dive into and get to here in a minute. So, but this is the precipitating charge. I mean, what's the most furious of this is this charge is a misdemeanor. That other charge is a felony. So now they're trying to tack on felony charges on top of this when this case here is flimsy as a frickin' feather. So let's dive back into here to this. Okay. This is all that's alleged on the information. It's just a copy and paste of what's directly in the law books. It says this information is based on evidence from this witness. And the witness is the police officer, the original arresting officer.
But the police officer didn't witness it.
There you go. Okay, here's how I broke this down. So, and Heather, I'm glad you're here because I haven't even had a chance to go over it with you. I sent it to you on Telegram. I want to make sure you got that. So, here's how I broke this down. So, everything's blacked out here. She is being represented by a county attorney, or not what am I looking for? A public defender. She's being represented by a public defender. And so his information's here. Normally I don't have a problem with outing liars with their names and stuff, but again, out of abundance for caution. So I just wanted to cover that up. So again, this is our motion to dismiss, the case number of the judge. Here's how I broke this down. Again, you guys, I've told you before that no matter what court you're in, they have rules that they have to adhere to. And as long as you put it on the record that those rules were not adhered to or they violated them, you have standing moving forward and getting any kind of a judgment vacated if this guy just blows this off. But I think this judge, when he sees this motion to dismiss, is going to have a really hard time blowing this off because, again, you two saw how flimsy that affidavit of probable cause and that information was. So let's go through this real quick. So I have here her name, the alleged defendant, and one of the sovereign people of Utah, by and through the Underside Council. There's his name, just so you guys know. In accordance with the Utah Rules of Civil Procedure 81E, and just so everyone knows, that is the rule that says these rules govern the applicability of other proceedings. And it basically states that if there isn't a specific rule under the rules of criminal procedure, then the civil procedure rules apply. So again, I'm holding their feet to the fire. We respectfully move this court under the Utah Rule of Criminal Procedure, Rule 25, which states when the court is without jurisdiction, it must be dismissed, to dismiss the above title action for lack of and want of subject matter jurisdiction, pursuant, can't even talk today. Pursuant. I guess I should have done my mouth exercises before we started. Pursuant to the Utah Rules of Civil Procedure 12B1, and for failure to state a claim upon which relief can be granted, Utah Rules of Civil Procedure 12B6, for defective pleadings, and as justice so demands and respectfully provides the following. So, first thing we do is we lay out the facts as they are alleged, right? This is the standard process when submitting a motion to dismiss. Is you're going to take, okay, what facts are before the court, alleged facts. Even though their pleadings are deficient, we're still going to take the information from them and just transpose it here to give the court that full picture. So that's all I've done here in item number 1 and number 2. Just reiterate what's in that information. Item number 3, we talk about how they said the information states the evidence to support these was obtained from a witness, the police officer with St. George PD. We talk about that the probable cause statement alleges that the defendant was arrested for this charge. Now, here's where we get into the good stuff.
So can I ask a question?
Go ahead.
Heather said she might jump in. I sent her the email, so we'll wait and see.
Okay.
Did Heather see the witness or know who it is?
Which witness?
The one the police officer's claiming or alleging gave him all this information for this affidavit.
I have no idea.
Okay. It'd be good to know.
I have no idea, and I believe she told me that she does not know who that witness was. So okay. I'm not entirely certain. So here's what they filed. So it says the city filed a probable cause statement for the charge of assault for the domestic violence, stating that the alleged defendant was arrested for this charge. However, upon review of officer's sworn statement, officer effected this arrest even though the alleged offense was not committed in his presence.
Oh,
He states as his basis for arresting the alleged defendant that video surveillance was obtained where it shows the alleged defendant hitting the vehicle and appears to hit the alleged victim. That does not give the officer what he needs. Okay. You're going to see how I tear this apart here in a second.
Yeah, there would have to be a big deliberation with jury if you're going to work on videotape, right?
Yeah.
Okay.
Yeah, because you have to be able to say, well, that's not the same conclusion I come to. Hey, Heather, how are you?
Right. I just had to turn on my radio because you're connected to my car. So I have to catch up now. Wherever you guys are in the speech, you might be a little bit behind or ahead. I don't know. So
well, if this is the first time I sent this to you, so you have it. But
I was in the shower.
This is the first time you're seeing this. I mean, my hope is that we can help a lot of people with this. So.
Me too.
All right. So. Yeah. So again, we want to go back and you guys, my whole purpose in doing this, and I take Richard Cornforth's stance too, is I want to empower you to win. And even though we could have attacked the insufficient service of process, lack of in personam jurisdiction, even though we could have attacked those modes, I feel like the nail in the coffin is the subject matter, which is what I've got right here. So that's where I want to go, and I want to focus on they need to prove they have subject matter, which they can't, and they don't, based on the information and based on the probable cause statement. So here's the first argument I'm making. Lack of subject matter jurisdiction under these codes for the information filed and the probable cause statement. So now I start bringing in some authorities. Utah Supreme Court has held that before the court is authorized to act, it requires an affidavit or other pleading of jurisdictional fact invoking the power of the court. Remember, you guys, what's missing from this pleadings? I've got a highlighter right here.
What's missing is the actual person, right? We
don't have an affidavit. There's no affidavit of anyone who's claiming injury.
You have an affidavit, but just not a witnessed one from the person who actually saw it. You have a witness of a witness.
Yeah, but
or the supposed victim. There's no affidavit from him either. And he was not pressing charges and he wasn't assaulted. I actually was, but that's a totally different story.
Yeah,
I don't know
that's a different story for another day. But yes, okay. There must be a victim, and there's no victim here. Okay, that's the point we're trying to make. So there's no affidavit. So short of that, this court has no jurisdiction.
Do you know the police officer or any of them, Heather?
I mean, I met with their deputies about a month ago, and because the police reports, I'm doing a PPO right now. This guy that was my victim was actually my abuser, and things just got worse after this incident, which was on October 20.
Well, my question was, before this incident, or have you
no,
met?
We had multiple interactions with the St. George police because Matthew was having the police called on him a lot. Like, people would see him throw me on the ground or chasing me down. I mean, I would love to share all of it with you. I actually compiled all of it.
Okay, so there's some history of them knowing who you are to some
Yeah.
degree. Okay,
Yeah.
that's just what I wanted to know, if it was just a cold case or there's some kind of history.
Yeah, and that's essentially what I've come to the conclusion here is instead of taking the actual victim statement, which is Heather, they decided to just turn this thing around and just make her part of the problem too. So here's how we're attacking this, guys, right? We're going right at the heart of the matter. They don't have any subject matter jurisdiction, and the probable cause, well, the officer didn't have probable cause, even though there is another document within the court document where the judge says, oh yeah, he had probable cause. No, he didn't. Okay. His own facts controvert that. So here's what we say. Number 6, upon review of the court records in this instant case, there is no affidavit or other sworn statement from the alleged victim claiming injury as a result of the alleged actions of the alleged defendant. The only sworn statement on file to date is that of the officer who based his actions and statements on hearsay evidence from an unknown, unnamed witness.
There you go. Slam dunk right there.
Okay. And then we talk about the lack of probable cause. And this is what I'm most happy with. And Brandon, buddy, the big Sib, thank you, because he turned me on to this. I said, based on officer's sworn statements, he did not personally witness the events that he alleges in his statement, and based on the facts provided by him, did not have probable cause to effect an arrest of the alleged defendant. Arrests of alleged misdemeanors not committed in the presence of a peace officer have been especially problematic as of recent. In fact, recently, the Idaho State Supreme Court held that warrantless arrests associated with domestic violence not committed in the presence of a peace officer are unconstitutional, according to the Idaho Constitution.
Yeah, that was real recent, wasn't it?
Yes, this was in 2019. They said the framers of the Idaho Constitution understood that Article 1, Section 17, which is basically the same as your Fourth Amendment federal rights, prohibited warrantless arrests for completed misdemeanors. We are fully mindful of the significance of this conclusion. Domestic violence is a serious crime that causes substantial damage to victims and children as well as to the community. However, this Idaho code permits peace officers to use their arrest powers to intervene in domestic violence situations, even though they have not personally observed the commission of a crime, and to thereby diffuse potentially violent circumstances. Nevertheless, the extremely powerful policy considerations which support upholding that section must yield to the requirements of the Idaho Constitution. Boom. Now, here's your next argument. Well, that's Idaho. This is Utah. Hold your freaking horses there, Jack. In light of this decision, including the Equal Protections Clause of the 14th Amendment to the United States Constitution, officers' arrest of the alleged defendant without personally witnessing the alleged defendant commit the crime she's being accused of violated her rights of unlawful search and seizure secured under the Fourth Amendment to the federal Constitution, applied to the states through the 14th Amendment and Article 1, Section 14 of the Utah Constitution. That's how we get over that.
There we go.
Okay. Now, let's just tear apart everything else. We having fun so far? Is this fun?
Yeah.
There's a lot of cases out there for this. So
yes. And just so everyone knows, I'm going to post this in our Telegram chat and wherever else we can post this in a Microsoft Word and any type of other editable format. You are welcome to take this, plagiarize it, use it to use it for your own case. Okay. All right, moving on. So number 10, insufficient evidence to support disorderly conduct charge. Further review of the officer's sworn statement shows that he failed to allege sufficient facts to support the charge of disorderly conduct, an infraction under this Utah law. By the officer's own admission, he did not personally witness the alleged infraction, but rather based his assertions on the statements of an unknown witness. The affidavit was, as sworn and attested to, violates the alleged defendant's right to be confronted against the witnesses against the accused. Article 1, Section 12 of the Utah Constitution. Officer's statement fails to show how he has standing to bring such a charge against the alleged defendant, as his own words fail to show that the alleged defendant's actions caused him any injury in fact. As such, there is no justiciable controversy before the court. Injury in fact is a prerequisite needed in order to invoke an Article 3 court and convey the needed subject matter jurisdiction. The court needs to adjudicate the controversy. Now, here I go. I've added some Utah Supreme Court cases because I really want to hammer these guys over the head. But in the absence of any justiciable controversy between adverse parties, the courts are without jurisdiction. Accordingly, to plead a justiciable controversy, plaintiffs must plead concrete facts indicating a specific injury sustained or threatened to the plaintiffs. Who was the plaintiff in this action again? Do you guys remember?
The city.
The town.
Or city. Yeah. So again, Heather, you must have one heck of a, I don't know, because you must be able to do some damage to the entire St. George.
I'm so powerful. I did make traffic stop one time.
Yeah.
But yeah.
In the moving on, in the absence of a justiciable controversy, the court lacks the power to issue a decision. With this information in mind, justice requires that this court dismiss this action with prejudice for lack of subject matter jurisdiction, as in the absence of any justiciable controversy between the adverse parties, the courts are without jurisdiction. Okay? I'm not done yet. I keep going.
Oh, yeah, keep going.
So, number 2, the city's criminal information is fatally flawed. Article 1, Section 12 of the Utah Constitution guarantees a defendant the right to demand the nature and cause of the accusation. According to the Utah Supreme Court, an information must contain a statement of the acts constituting the offense in ordinary and concise language, and in such manner as to enable a person of common understanding to know what is intended. Real quick, let's go back up here to the information. Having that definition in mind, does this contain a statement of the acts that constituted the offense that's being alleged?
Yeah, that's just a copy and paste of the manual that's listed in the law.
This right here, people,
Lazy.
is exactly why the United States Supreme Court, in the decision of Ashcroft v. Iqbal, which upped the standards of pleadings, this right here is why they did that. Right? Mere recitations of the essential elements will not do. You cannot just copy and paste what the law says into your complaint and call it good.
Yeah, that's lazy.
That not.
Well,
it's not
you
only
can.
lazy, I mean, again,
Whatever they
guys,
want.
Erica, you're asking too much of these poor prosecutors. They are so busy. They can't sit down and write all of the facts and everything that needs to go into these stuff. Come on. You can't be serious to ask them to do that.
Leave
So
it wide
what-
open then. Go ahead.
Will they claim the section where the body of this that lists out what the witness witnessed as such facts?
Well, again, we just tore that to pieces, didn't we? What witness?
Well, that's the thing.
Right.
Yeah,
I mean,
where-
those cops could have driven there with nobody talking to them and just said, "Oh, we got a call from a witness." Like, if they had it out for me, I mean, I'm not saying it was a conspiracy, but I'm just saying when you at the face of it, when you look at it like that, because like I said, the supposed victim. Now I don't know what he said to the cops. He's told the cops I strangled myself, so I have no idea what he said. But
well, you must not have done a pretty good job because you're still talking to us. I'm just saying.
Yeah.
Yeah, well, I'm just saying that I don't know what he said to them, but he's not pressing charges. And yeah, like this person, they could have never existed. You know, What really breaks my heart about this whole thing is, yeah, they didn't put any of my testimony in there, like that he spit in my hair and then he spit in my face and then he twisted my arm and, all of that. None of that, or that he stole something from my car, which I found out later was my driver's license. But they didn't even get the camera for the parking lot that would have, at least lined up with what I said happened at all. They didn't pay any attention to what I had to say. But you know, my ex, you know, if you know anything about abusers, they're very manipulative, and you know, he's very charming. So guy, don't you know?
Yeah. Well, and it's just, it breaks my heart. You know, I that's just,
thank you.
There's just nothing worse than it, because, you know, Justice said this. Was it you, Justice, or Erica? You know, it said, you know, okay, all right, people, this might ruffle some feathers, but males inherently are stronger than females.
Oh, I said that. Well, it's a fact. It's not
just it's biological.
That is scientific fact. Okay, I can go to the gym and I can pound weights and I'll put on twice as much muscle as a female would, my same size, my same weight, and everything. Okay. There's just no way. It's just physically impossible.
This guy is 6. I'm 5'2", he's 6'3", and he could bench press over 200. So he's very strong, very strong. Yeah. Gave me 2 black eyes without a fist, you know.
So that's, again, going back to where we are. That's why it frustrates me when you read the affidavit of probable cause. Nothing that you stated was there. You know, I would love to see the affidavit of probable cause for your ex's case, because I'm willing to bet nothing that you stated is in there either. So anyway, getting back to the matter at hand, what we want to do is we want to pick apart their pleadings.
Right.
Okay. Again, I'm telling you, people, please listen to me. Do not go into court saying, well, I'm a sovereign and you guys can't do this to me. That's true. You are a sovereign. But if you go in there and say that, they're going to railroad you. Don't go in there and say, well, you guys spelled my name wrong on this charging document. It's all caps and I'll spell my name. Like, don't do that. You're hurting yourself. You're not giving yourself any way of winning. And this is why I said I could have attacked the insufficient service of process. I could have done that. But I'm like, do I want to waste the time on that for something that's so minimal? Let's get the ultimate dagger. Let's get the thing that's just going to put this baby to bed. And this is it. This is how you do it. So we talked about here, number 13, where she has a right to demand the nature and cause of the accusation. So here's where I love this, and you're going to love this part too, Heather. So the probable cause statement obtained by the officer alleges that the alleged defendant took a glass bottle and tried to dump the liquid contents onto the alleged victim. Officer then goes on to say that the witness that reported this alleged offense said that the alleged defendant hit the windshield with the bottle and licked the door.
Oh, yes.
The door.
We wanted some clarification.
Yeah.
So, you put a typo in there, James. I was like, oh, wait, why does it say lick the door? Does it really say lick the door?
I copied that word for word from his affidavit of probable cause.
We just wanted to know.
That was good stuff. Never happened.
Was that like a what was in that bottle?
Kombucha. kombucha was in the bottle.
Oh, kombucha.
Windshield.
You don't want that stuff to go to waste. You got to lick that door.
Well, I just thought it would be stinky. I mean, his car is a total shit hole, but I did not hit the windshield with the bottle. Matthew got that out of my hands real quick. He snatched everything out of my hands. But as soon as he got to me, there was no more kombucha in my hands. He got that bottle and he put it back in my car. I didn't know he said I licked the door. Dang it.
I had to laugh at that one too. If you guys don't believe me, I mean, here, I'm going to go right back up here.
I'm going to have to go back to the freaking statement and read it.
Here it is right here. The witness stated the female hit the windshield with the bottle and licked the door. So
how dare they talk to me like this?
I know. All right. So let's move on. While the charging document is unclear if the completed act or if an attempted act is charged, if the intended charge is domestic violence, assault, and disorderly conduct, the information and probable cause statements are fatally flawed in that there is no completed act of domestic violence, assault, or disorderly conduct verified by an actual victim, sworn statement, or affidavit, or personally witnessed by the reporting officer.
There you go. Slam dunk. There it is.
Hearsay evidence cannot be entered into the court as verifiable evidence, as it would violate the alleged defendant's right to cross-examine any witnesses against them. To allow this hearsay evidence as prima facie evidence of the alleged offense makes a mockery of our justice system and directly violates the alleged defendant's rights and the rules of evidence in this court. This right here, Utah Rule of Evidence 802, this is the rule against hearsay. What have I said about rules, you guys?
They have to follow them.
Rules rule!
Yeah, man. Oh, wait.
Okay.
You know, it seems though, as long as you know the rules, if you don't know the rules,
Well,
they've
here's what I'm going to say to that.
finagling.
Here's what I'm going to say to that. If you don't know the rules, shame on you, because they are published right out there in the open for anybody to access. Every single rule that I'm citing here is available online. If you don't have internet access, you can go down to your local library. They're all right there available for you. Everything's there. So you have no one to blame but yourself if you don't know what rules these courts are required to follow. Now, these courts, injustice courts will try to skirt the issue all the time, but you're backing them into a corner. If you guys can't tell, I'm backing this judge into a corner. What were you going to say, Justice?
Well, you know me, I'll say it again. As much as I've heard you talk, and we've been 2 years, I think we've known each other now. For a lot of people, it doesn't stick in the brain, the legalese and these types of things. I'm one of those people. So I would still call you, James, what are the rules?
You know, just try to
but shame on you if you're not trying to learn them.
Yeah, just keep it simple. Just keep it simple.
If you're not doing anything.
Exactly. So moving on, in this matter, the city relies solely on unverified witness statements as to the alleged acts that precipitated the alleged offenses of assault, domestic violence, and disorderly conduct. These statements, even if they are true, do not support conviction of domestic violence and disorderly conduct. Therefore, this court should dismiss these charges. So, what do we think so far?
It's great.
Okay, but I'm not done because I'm having fun.
You keep going.
All right, so number 3, the city's criminal information fails to state a charge. United States Supreme Court has said it is well established that an indictment must allege all the elements of the charged crime. An essential element of assault domestic violence as charged on the information in this matter is that the alleged defendant did attempt with unlawful force or violence to inflict injury, blah, 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 blah. The last one, furthermore, the defendant was a cohabitant of the victim. Okay? What do you guys take as that as cohabitant? What does that mean?
You live together.
Yeah,
you live together, right? Heather, where did this incident take place? This alleged incident?
In a parking lot.
Not your house, though, right?
Right.
Okay. And nothing you guys saw in the probable cause statement would suggest otherwise, correct?
I mean,
it says very clearly it was in the parking lot.
Mm-hmm.
Okay. Perfect. Here's what I say. The facts alleged in the information require a brief description of the alleged defendant's conduct, as well as indisputable evidence that the alleged defendant is a cohabitant of the alleged victim. Upon review of the information, no such facts exist. The city has charged, based on the court's charge code and title section, the completed act of assault domestic violence. If this is the intended charge, the city has failed to plead the essential elements of the alleged defendant's conduct as witnessed and sworn to by a witness with personal knowledge of the alleged conduct and any evidence to suggest that the alleged victim was, at the time of the events, a cohabitant of the alleged defendant. You see where I'm going with this?
Mm-hmm. It's not domestic, people.
You can't support this charge. Okay?
Right.
Can't support the domestic violence charge because you have not pled any facts that state that you guys lived together. I mean, he stated that you were in a sexual relationship.
Right.
Well, somebody had to have said that for him to know.
But exactly. And according to the officer, he said that the alleged victim, Matthew, is the one who told him that. Okay.
Let's talk about that.
But guess what? How many, and I fear I'm opening up a can of worms here. How many people are in sexual relationships but do not live with each other? I mean, gosh.
A lot.
A lot of people.
Do you guys live together, Heather?
No.
Okay.
Live with me is crazy.
That's my
neighbor
point.
would kick us out.
So guess what is an essential element of that statute?
So that's completely wrong then. The cohabitant is totally wrong. Okay.
Yeah. You have failed to prove or allege any facts that would prove that these two live with each other. So,
Boy, you're just like
I'm having
getting
fun.
it in there, James. And furthermore,
Oh, wait, I have more. If you thought that was all, I have more.
I can't wait for the response. This should
So
be
I
fun.
state here that the Utah Supreme Court has made it very clear when it comes to indictments, informations, all of the essential elements and the facts supporting those elements must be presented in the pleadings. The city has failed to do so. Now, here's where it gets really fun. I mean, if that wasn't fun already, this is where it gets really fun.
oh, good. I'm looking
Item
forward.
number 4, justice demands that information be dismissed. The city, the alleged plaintiff in this matter, is attempting to move administratively according to the provisions as outlined in Utah Code 63G 4102. This is the Utah Administrative Procedures Act, people. Read it, because you'll see, you're like, holy crap. This is exactly what's going on. It says the city has failed to produce
there's an
verifiable evidence on the record that the alleged defendant is subject to the provisions of this statute. The record clearly shows that the city is attempting to deny the alleged defendant her unalienable rights as enumerated and secured by the Constitution for the United States and the Utah Constitution, namely her right to know the nature and cause of the accusation or accusations against her, her right to face her accuser, and her right to a speedy trial by jury. The city is attempting to bypass the alleged defendant's rights in an attempt to extort monies as fines within a simulated legal process. You like this, Erica?
Yeah, I'm loving it.
The Utah Supreme Court has held
I love the end of that line.
unconstitutional when applied to a private citizen. Accordingly, abbreviated administrative type proceedings are constitutionally insufficient in the context of criminal investigations by the state's prosecutors. Dilution of citizens' rights by a strained analogy to administrative subpoenas and procedures simply ignores the fundamental safeguards that the law has always recognized in criminal procedure for the protection of individual liberties. That's straight out of the Utah Supreme Court, folks.
That's awesome.
1988. It gets even better. Reading further into this case, the Utah Supreme Court determined that in a series of cases, the United States Supreme Court has established a system of classifying agency proceedings and describing generally the type of safeguards required in each class of proceedings. These cases indicate that the requirements of due process vary depending on the nature and purpose of the proceeding and the likelihood that it will result in the deprivation of liberty or property. All proceedings fall into one of two major categories: adjudicative or investigative. Adjudicative proceedings are essentially judicial in nature and result in binding determinations that directly affect legal rights. The full panoply, that's an interesting word, of procedural safeguards available in judicial proceedings are therefore available in adjudicative proceedings, including the rights to present evidence and cross-examine witnesses. Whoa.
You just attacked everything they are.
Exactly. Exactly.
Well, can I just say, as a victim of actual violence from this man, the fact that most of his assaults were just these in this administrative court where I was pressing charges. He's not pressing charges, whatever, in this situation, but where I didn't use the criminal justice system just to, play cop or good cop, police my relationship. If I called them, I wanted them to press charges because I was pressing charges, and they're non increasable. So he's got all these misdemeanors. Finally, he almost killed me in November, end of October, just middle of November. So now he's in jail. He's got actual charges in the higher court, but there was multiple misdemeanors. First time he ever came to St. George, he strangled me, and I didn't want him in this city. I didn't want him in this state. So then he came back here and started wrecking my life, literally. But
here's what infuriates me beyond all belief. we have these laws, right? This domestic violence assault laws, but it's a mere misdemeanor.
Right.
Misdemeanors mean nothing. Now, if I claim injury, for example, Heather, in your case, where he physically harmed you, that
Right.
is a felony, and I don't care what state you're in. That is a common law cause of action. Okay, you hurt me, you physically caused me injury, and I have standing now to prosecute you. Now, we generally will turn that over to a district attorney or something else of that nature to handle the criminal side of things, but you can also sue him civilly. Now, he probably doesn't have any money, which is okay, but that's my point is.
I would like to sue him, yes.
Yeah. So this is what frustrates me is rather than dealing with this issue up front, they let this thing fester and fester and fester with all these little teeny tiny miniature misdemeanors. And then ultimately, thank heavens you weren't seriously hurt or, heaven forbid, killed.
No, I mean, I did have to beg for my life from this man. So, I mean, I am hopefully not permanently scarred from him, but very, very not well. I'm doing better every day.
Good.
Through Christ who strengthens me. But yeah, it's terrorized by this man.
So sorry.
And this is all
I can only imagine. So
this is God's plan for me to be part of this process and sharing how we get through this, because I've been victimized by the legal system as well. But we're here to fight.
Yeah,
so we're gonna get this.
So here's let's conclude, and here's where we end with this. So, where I stated the city's information failed to inform the alleged defendant of the nature and cause of the accusations against her, as well as failed to inform her of the witnesses against her with personal knowledge of the alleged conduct, justice demands that the information against the alleged defendant must be dismissed with prejudice. I have a little footnote here. It's this one right here. See Utah Rules of Evidence 602. That's the same as in federal rules. It is the need for personal knowledge. Any witness claiming anything must have firsthand personal knowledge. So that just voids out that officer that his entire testimony is worthless. Okay?
Yeah.
So here's our conclusion. The city's information and probable cause statements are insufficient as a matter of law due to a failure to plead the necessary elements and facts supported by an affidavit or affidavits of the alleged victim and or witnesses with personal knowledge to support a conviction of either the assault, domestic violence, or disorderly conduct. Therefore, this court should dismiss the pleadings with prejudice. Additionally, the city's filed charging documents are void as they fail to allege essential elements and facts required to be pled on criminal informations. Lastly, the city is attempting to prosecute this case administratively without affording the alleged defendant her constitutionally secured rights. Due to their decision to bypass an Article 3 court of record, they should be barred from prosecuting this incident, and the pleadings should be dismissed with prejudice. That's basically what we say. Request this court finds it doesn't have jurisdiction, and that you dismiss this case with prejudice. Okay?
Great job.
Thank you so much. It's incredible. What does that mean with prejudice? That don't forget? What does that mean?
No. So with prejudice means that they can't come back and try to re-prosecute you again.
Oh, okay.
For the same incident, right? For the same charge. So,
okay.
So I'm not quite finished with this. I'm also going to send over to you, Heather. I'm going to send over to you an affidavit in support of the motion to dismiss, where you're going to state that everything in there is true to the best of your knowledge. It's just going to make it, again, affidavits, hence the name of my group, Affidavits 101. They make everything stronger and better as far as your pleadings before the court. So make sure that liar who's representing you does not change anything in there, because you have a copy of it. So I'm sure he's going to be squirm. He's like, oh, I'm not going to file this. He's like, well, guess what? You're going to file it. Otherwise, I'm going to bar grieve you. Oh, and I'll bar grieve you just for fun. So, bar grieve you
what would be the grounds that I can bar grieve him?
Because he's not doing what you're asking him to. He's not doing anything.
Okay.
He's not upholding his oath of office. I mean, gosh, just pick something. So
okay.
Just say the word bar grieve. Heather,
What's that?
just say the word
Oh
Barbary.
yeah. Well,
Just-
That's-
so this
just
is
threaten
this
them.
is the lower court. Yeah, this is the lower court. I haven't even spoken with this attorney because this hearing isn't until May. Meanwhile, I'm being charged with violating a protective order, which actually is a lot of work, and I did not violate a protective order. And though I have to plead on Wednesday, not guilty, but they've been trying to get me to take a plea in abeyance, and I mean, there's a total conflict of interest because my abuser has been having his trials in the same court. And so I've been going there almost every week until December 21st. So for 5 weeks in a row, I had to go there and make sure they kept him in jail because I didn't want him released on a tether because this man is, terrified me. He's horrified me. So the same courtroom, the same judge is trying me. That is also going to be listening to me as a victim ask for sentencing for this man. I mean,
Wow.
that seems totally against all custom. And then the defense attorney that's called me poisonous and toxic believes every line of BS I guess Matthew has told him. My supposed defense attorney has been sitting next to him through every single one of these hearings. Oh, and they go drink and whatever together. But it's like I couldn't get another counsel. They would not grant me any other court-appointed attorney to help me. They were like, well, if you don't want to do it, you can have this guy or you can have your ex's attorney. Like, sorry, like they gave me no choice. No
Oh.
choice.
So are you going to fire that attorney?
Well,
Well, if I fire, that means I have no attorney.
Yeah, this is
Well,
what she's.
I can't
Yeah,
get other one.
and I'm just here to tell you guys, I would not recommend going at this alone in these injustice courts because they just. I have not seen anything good come of it. So.
Oh yeah, when people represent themselves and don't have their attorneys just file the stuff.
Yeah, just give it to the attorney and tell him you're going to file this. You're going to file the documentation I give you to file, and if you don't, I will bar grieve you every week until the end of the year. And that should scare the daylights out of him. Now he's probably going to say, "Well, go ahead. I don't care. That doesn't mean anything to me." Well, it does because your insurance company is going to take note of that. And if you can't get errors and omissions insurance, you can't practice law. So, tough luck.
I thought I read somewhere in Telegram that they said that in Utah that they don't require the attorneys to have insurance.
No, that's not true.
Is it?
That's not true.
Okay.
No,
Okay.
All liars are required to have insurance because again, they are in an inherently risky business anyway. So, and then I wanted to touch on real quick too, Heather, you just talked about, they said you violated a protective order. So I have gone through every document you've given me in the precipitating case. There is nothing even remotely close to a protective order in that docket. So what is this protective order they're talking about?
The jail release order.
No, it's not there.
When they let me go.
There's nothing.
Oh, you don't have it at all?
Yeah.
Oh,
And if you don't,
well, I can scan in I still have the ones, the paperwork. And I was actually released from jail, and then I signed some other piece of paper. That was the you can't see your boyfriend paper. But those were two separate processes. Like I wasn't released pending these things. It was you're released. Oh, wait, before we let you go, after you've been freezing in that room for a while, sign this too. You can't see your boyfriend. I mean, the supposed victim.
Yeah, there's nothing in the court docket. So
okay, well,
what is this protective order that they're trying to base
right.
this other crap off of? Not only that, I did find there's one document that says order to release with conditions, and it says here this was signed. This is actually signed by the judge. It says you're released pending these following conditions. You promise to appear for all the proceedings, promise not to commit any criminal offense, report your contact information with any changes, and you have to sign the jail release agreement. Okay. So then I find in here the jail release agreement, which is on the 24th, has a bunch of stuff here. But I've been through this document 2 or 3 times. I can't see anything in here where it says you're not allowed to go talk to him.
Yeah, that was a separate piece of paper they had me sign on the 21st because they arrested and released me on the 21st and then arrested me again on the 21st. And then I was in jail for 3 days. And then my ex-boyfriend bailed me out of jail. So he came and picked me up again from jail. Like that.
He's not pressing any charges.
No, he wanted to be with his woman. he would say whatever he could to get away from the cops. He's
Yeah.
a liar, and that works for him. I tell the truth, and that should have worked, but it didn't. So, and I
Well,
think the cops were just sick of seeing his face.
Yeah. Well, if you can send me that protective order, that alleged protective order, I want to take a look at it because I'm going to need that. I'm going to need that to write up your motion to dismiss in the next case. So here's a great question I want to put up on the screen. Ian says, could this case fall under vacating a void judgment if the city were to succeed in this case? Abso-freaking-lutely. Yes. Yes, it would. We could attack this one. We could attack anything with it. So this is exactly what I'm talking about, is these types of cases where their case is flimsy as a feather. They steamroll you and they railroad over you anyway, and then you're left hanging out to dry. Sometimes in this case, the recommended fines were like almost $2,000 that they wanted to charge Heather. So that's just the actual monetary fine. Never mind the time she actually spent in jail, her liberty. I mean, you can't put a price on that. So, and
the trauma that these men that were supposed to protect me and serve me threw me in jail when I was assaulted that day.
Yep.
I mean, the terror, the horror, all of it.
So the real victim here, the real victim is Heather, and instead of stepping up and defending her, right? They always say to protect and to serve. It's like you're not doing any of that. You're not listening to me. You're listening to what some jacko sitting in his other car thought he heard. That's not really what happened. So
James, at what point would it become appropriate to do an affirmative defense? Like, you just did a motion to dismiss after the meetings, but she's got enough information to go on the offense here. Really,
she does. I mean, and essentially, I listed those affirmative defenses in there, right? Where I say this court doesn't have subject matter jurisdiction. There's nothing on the record that would grant this court the jurisdiction it needs. So that's part of what I did. Now, if they just willy-nilly deny this, which is possible, I'm going to say it's probably like 60 to 70% possible that this stupid judge is just going to blow this off. If that's the case, okay, no, go ahead, judge. But you're now going to be a named plaintiff, and we're going to attack this collaterally because, again, your liberty's at stake here. So we have to get this resolved. And we want to get this resolved in a way where you're not sitting behind bars somewhere, because that doesn't do anybody any good. So,
right.
But again, if you have, then you're going to take it to trial. You're going to demand. No, I have a right to a trial by jury to say, oh, well, we'll get 3 or 4 individuals. No, I have a right to a trial by jury of 12 of my peers. You are not going to pull me into one of these ridiculous little courts that you hold here in these city offices. That's not how this works. So we're just, again, if you guys can't tell, I'm putting the court on notice that their game is up. You guys can't be prosecuting us administratively anymore. You do it right or you don't do it at all. So.
God bless you. This is coming right on the heels of the city attorney trying to secure free speech zones in St. George. So this is...
don't get me started.
We're gonna help down the sales over here.
He's got something else to answer for with his drag shows and all these other things he's been doing. So that's a story for another day.
Right.
Anyway, with that in mind, we're going to wrap it up here. We're just a little more than an hour and 20 minutes. I know it's a little longer today, but I really wanted to get through this. So for those of you who are listening, either on podcasts or whatever, you can find this motion to dismiss in a Word document. I'm going to post it in our file section of our Telegram channel, affidavits101/TJR. I don't know. Justice, can we post it anywhere else too?
Well, here's all our channels.
Okay.
So if you want to subscribe, Affidavits 101, and then we're on pretty much everything. So we can post it on YouTube, Rumble, Cloud Hub, Social, Truth Social. And if we want to update things that you think are important, the website needs updating, people. So maybe James can rack his brain of some really good examples that we can get up there.
Yeah, we did that. We put that website together, almost 2 years ago now, Justice?
Yeah. Yeah. So we need to adjust it and update some certain things, but
yep, we do. So
anyway, do you remember meeting me? Do you remember when I did a Zoom with you in Sedona? Do you remember you and another woman? That was you, right, Erica?
Erica's in Indiana.
No, Erica's in.
No. I'm saying I was in Arizona at the time. It was right around the time I met this guy. Anyways, you don't remember Erica? I'll look for it. It was you
Okay.
and some other woman. We just had a chat one Sunday afternoon.
Huh.
Yeah.
You sure
Okay.
it's me? I don't know.
Mm-hmm.
Were you in Arizona?
Patriot
when you
Angel
heard
on his page. No. We did a Zoom call. She wouldn't. I don't even know why I brought up
Oh,
Arizona. You
Zoom
wouldn't even know I was
call.
in
Oh,
Arizona.
okay.
I
It was
said that
probably related to
confusing
your.
everything.
Oh.
Yeah, it was probably related to your other venture that you were hinting at earlier. So, for those of you who remember the cliffhanger, Erica's hoping to have some really big news that we're going to share on our next podcast / broadcast / whatever this clown show is that we call a broadcast. So
It's a moving infographic.
there you go. Ooh, I like that term.
So you guys, if you would subscribe to Rumble and like it, whatever platform you're on, if you like and subscribe, it helps us. I never wanted to say that because I always thought it was corny, but now that I know more about techniques,
Yeah.
it helps the algorithm get your feed up in more people's faces. That's the whole point of it. If you didn't know, it's not self-soothing. It's just so that the algorithm, then the more attention it gets, the more likely it is for an advertiser to want to advertise with the platform because you get more eyeballs.
Yeah.
Not that we're going to put advertisers on the platform, but that's what that's about. So it just helps us help more people, basically, in a nutshell.
Yeah, and thank you everybody who's subscribed under Rumble. And last time I checked, we were at 110 subscribers.
Oh,
I think.
Good.
So I think we can start doing live streams through Rumble now, which is good.
We'll do a live there next week then, the next one.
Awesome.
Let's have you checked the questions before we pop off here?
Yeah, I looked at them here. Ian has a couple of things that they're more statements than anything else.
Okay.
I put up this question there. Thanks, Ian, for being here as always. I really appreciate you joining.
Yep.
So, see if there's anything else here. I don't think so. Erica, any closing thoughts?
I don't know. Just I've just been it's too much. What my closing thoughts are too much because I'm just coming into this realization of how much thuggery and mobster mentality, like instead of calling them thugs and mobsters, we call them judges and lawyers. It's like this, and then they're licensed.
Yeah.
They're okay to do this stuff. They're okay to take money from you. They're okay to rob you of your rights because they're doing it as your government. They're doing it for the people. No, they are thugs and they are mobsters, and we have the right and the duty to stand up against them, to become informed, to find out what their game is, and then be way better at it than them.
Mm-hmm.
Yes, great point. Yes, you guys noticed. By the way, I don't remember who it was. Our last episode was asking if I had a foosball table in this room. Yes, I do. Okay, we got my kids a foosball table for Christmas, and so after we had that, I'm like, okay, I'm going to put up a banner behind me. So hence the We the People, right? We the people have the right and we have the duty to alter or abolish the government. Now, I'm not suggesting we do that because the government that our founders put in place is by far the best government that's ever been instituted among men on this planet since the inception of this planet. But that doesn't mean that we, the citizenry, can just go along to get along. That's our job is to know our rights, to make sure our public servants know that we know our rights and that they secure those rights, because that's the only reason government is instituted, is to secure those rights. And so when they become the tyrant, when they become the abuser, then we go on offense and we start to stick it to them. And this is the way we do that. So with that, everybody, Heather, thank you for being here. And again, I apologize for just putting this impromptu on you, but thank you for joining us.
I honestly did not know you were going to cover this in the talk, but you've got a lot going on. I can't believe this. I mean, I'm glad it was good content for the episode.
It was actually a lot of fun. I really enjoyed this. This is, and Justice knows, I'm one of those weird guys where I have a lot of fun writing stuff like this and sticking things in people's faces. So I really enjoyed it, but I also thought, hey, I feel like this is something that could really help other people know how to attack these types of things. Because again, this is all part of our due process rights. These are the procedural due process rights that must be in place. Otherwise, this court has no controversy before it. So
And can I just add something, because there was something about James when I met him, and he has a burning desire to help people. He's such a good heart, and he does all of this stuff for free. He's constantly helping people, and he's got a very large family. He's got small children.
Whoa! Wait a second. Large family?
Yes, you got a large family. I got 2 kids.
Okay, all right, fine.
So,
I've got 5, plus I have an adopted nephew, so.
To me, that's a large family. Well, maybe not in Utah, but to me, it's a large family.
Yeah, that is, well, hey, it depends on what part of the country you're in, right? If you're in Jersey with the Jewish communities, I'm halfway there.
Yeah.
Because most of those families have 12 kids.
Yeah.
Well, God bless your wife.
You're a third of the way there.
Yeah. But anyway, so he's been dedicating his time, blood, sweat, and tears to helping people, like Erica. He helps Erica. Erica's got a case too. If no one's ever seen this, she's a critical care nurse who was unduly fired because she didn't do the imposing medical procedures. So he helps whoever he can all the time, nonstop. And I just want to thank you for that, James.
Well, thank you. Again, I can't live with myself knowing my brothers and sisters are being wrongly accused and prosecuted accordingly. So,
well, God has called some of us for this time and gives us a burning desire to do it, and you are one of those people. So
I agree.
Yeah,
I agree. So
Erica too, all in our own way. So
yep. All right, everyone. Well, thank you so much. Again, we went a little longer than I like to, but that's okay. It was good information. I wanted to make sure we got it out. So thank you to our guest, Heather, for being here. Thank you to my co-hosts, Erica and Justice. Appreciate you guys. With that, everyone, enjoy your Monday. Enjoy your week. Hopefully we'll have another episode. I guess it must be getting late in the day. I don't know. Hopefully we will have another episode this Friday. Until then, you guys, God bless you all. Take care.
Okay.
God bless you.